Call the case of the people of the state of Michigan versus Robert Heft.
Good morning, Your Honor. Amy Reiser, appearing on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Heft. Mr. Heft, can you state your name for the record?
We are getting him right now. Hey, Robert, I got you for a thing real quick. Yeah. I don't think this was.
Is that Mr. Heft?
Yep.
And the
All right, defendant is present. Go ahead.
Your Honor, I received a report stating that Mr. Heft was incompetent and not restorable within the time frame. I would stipulate to the court and did prepare an order to the court for signature regarding that.
And is not restorable.
It's not restorable.
All right. Any response from the people?
No, Your Honor, I am not able to get into the county system this morning, but I would not dispute Ms. Apple's representation.
That is what the report reads. The defendant is found incompetent. How are the people going to proceed?
So there's an option on there that we file a petition, and so I need to review the file to see if we will file a petition for commitment.
All right. So what I will do is I think
check it and we'll get it filed.
all right. Well, the question is whether I set a new date so that we review it. Otherwise, it's just going to sit there if something falls to the cracks. So why don't how long will that take you think?
Excuse me?
Yes.
Hi. Sorry, I work here in the court office where Mr. Heft is hospitalized. I just want to let you know we have already completed the petition and certs to probate him. So it's already been completed with Washtenaw Probate Court.
Oh, fantastic.
Then my office won't file a petition. Thank you.
All right. Then what I'm going to do is I'm just going to find him incompetent. And you'll have to at some point send a nollie process.
Yes.
No, I suggest you go back to school there, Judge. I'm not incompetent.
Okay. Thank you.
The letter, or do you?
I'll do that this summer. All right. Thank you, Mr. Heft. Court does call the case. The people versus Andrew Krupa.
And good morning, Your Honor. Uwe Daus on behalf of Mr. Cooper in both files. There.
Do we have it?
He's at MVOC. He must have stepped out. He's right there. Just yeah.
Mr. Krupa?
See him listed, but not in the room.
There? Yeah. My label is just covering that. Mr. Krupa? Okay, so it's going to be that kind of day.
That's okay. I'll take a seat.
Huh? Okay, I'll pass it.
Thank you.
You see him wake up. Let me know. Court does call the case. People versus Sean Burrow.
Actually, lots of people.
You have a wad? I have a early.
Would you call, Your Honor? I'm so sorry.
Mr. Burrow.
It's Mr. Mawad's case.
Okay.
Has he filed a substitution?
I don't know, Your Honor, I have seen him this morning. Is
he intending on joining us?
He wasn't here early. Sorry, Judge.
It's okay. Everybody was pleased with waiting.
Well, if you're going to send me away to the jail, you remember my cousin Vinny? He went in the school bus. I want the school bus. So.
Okay. All right.
Elias Muad appearing on behalf of Mr. Burrow.
Yeah, people are going to be nollying his case, so that will be so overshoot.
All right.
Better not object.
Then I will. I assume there's no objection.
No objection.
All right. So this case is dismissed and I'll sign the order when it comes in. Mr. Burrow, he almost blew it. I'm just saying. All right. Thank you.
Thank you, Judge.
Court does call the case of the people versus Samantha Cosley. Cosley.
Ready, Your Honor.
And good morning, Your Honor. Joseph Hall appearing for and on behalf of Ms. Clausick, who stands to my right. Ms. Clausick, if you could state your name for the record, please.
Samantha Nicole Clausick.
Thank you very much. And Your Honor, at this time, we have executed paperwork, and I've advised my client regarding her rights moving forward. She would elect to waive preliminary examination and proceed to circuit court.
This is a operating while intoxicated causing serious injury.
That's correct, Judge.
And does she have a medical marijuana card?
Your Honor, she has an expired one and she has an application.
And why is she using?
Your Honor, we don't.
Mr. Allen.
I would not advise her to comment on that. But Your Honor, she does have a doctor who has certified, who has executed the appropriate paperwork, which is sent to the state. We believe that card is in the mail.
I didn't hear the court's, I'm so sorry.
When was that done?
That was done immediately after she exited Maple Grove, Judge.
Immediately after what?
She exited the inpatient facility where she was in between the last hearing and today. So we do have some documentation, Your Honor, from the doctor's office.
When did she get out of the facility?
I have precise dates in my phone.
I went in on the 6th.
Yes, I believe it was the 22nd. Well, her appointment with Dr. Durinka was January the 22nd, Your Honor. So at that point, she was out of the facility.
When did she go in?
The 6th.
The 6th of January.
Came out the 22nd.
Your Honor, it was close to, without going back to my file, I don't want,
That's fine.
okay,
But, and then he's using.
with Dr. Cert, I understand, Your Honor. Yeah, I mean, I'm not going to dispute the drug test.
Counsel approach.
Yes, Your Honor. Thank you, Your Honor.
All right.
Your Honor, I appreciate the bench conference in this matter. At this point, while we have a lot of what I would call circumstantial evidence of what we've already said, that there's been an application made, we believe it's going to produce a card. We understand Your Honor's position that right now, technically, we're in a legal gap there. And we understand the results of the test. We do not dispute the results of the test. I would ask for the shortest possible adjournment. Ms. Clausick was being tested while in the Maple Grove facility. We're going to get those test results and forward them to Your Honor as soon as possible. For now,
once I get those, I will reconsider the decision I'm about to make now. But given the nature of the charge in this case, with operating while intoxicated causing serious injury, she's using. Prior to her going into treatment, there's cocaine and 2 other drugs in her system, comes out of treatment, and now I still have another drug in her system that cannot be tolerated and won't be by this court. So at this point, I will adjourn the probable cause conference to February 6, 2025 at 9 a.m. At this point, defendant's bond is revoked. Defendant's remanded.
And Your Honor, one more point. I do have a letter from her medical doctor regarding her future testing, stating the basis for a recommendation of swab testing. I can provide that to both Sister Counsel and Your Honor for when eventually she is released, and we're going to.
Well, if you hold on to that, then I'll certainly address it next week.
I'll send this with the test results, Judge, to all parties.
That'll work.
Thank you, Your Honor.
All right, thank you. Mr. Krupar, can you hear us,
Yes,
sir? Oh, okay,
Yes.
now you can hear us. All right. Court does recall the cases of the people versus Andrew Krupar.
Uwe Dals on behalf of Mr. Cooper on both files. Thank you for recalling it.
All right. You're requesting an adjournment.
Yes, please, on both files for discovery on each. There's not much on the file ending in 1221, only one item essentially, but on the other one, I think I expect a large number of items still to come in discovery.
All right. He's not close to being let out or anything at this point.
No, minimum term 28 months, and he's maybe 2 or 3 months into that.
All right. Probable cause conference, I'll adjourn to February 20th, 2025, 9 a.m.
We had one item of housekeeping. I think on the file 1221, Mr. Cooper had been referred to community corrections. We keep getting reminders that he's not in compliance with that. We wonder if that referral could be removed, given his prison term.
Okay, I don't know why they're sending reminders. That's not our process, but I mean, nothing's going to happen, the standard condition, because they don't know if he's going to be released. So it's in there, but you'll have to deal with community corrections, let them know where he is.
I think we did that. Yeah.
Bond will continue.
Very good. Thank you.
Thank you. Call the case of the people versus Jeremiah Driscoll.
On behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Driscoll. Oh, you got him? Okay.
I'm sorry, Your Honor. Another emergency popped up. Mike Gaddy, Assistant Public Defender on behalf of Mr. Driscoll, Judge.
Your name, sir?
I am Jeremiah David Driscoll, Your Honor.
Thank you, sir.
You're welcome.
Your Honor, I believe we have a resolution in this matter.
Okay.
I believe that Mr. Driscoll will plead guilty to count 3. Counts 1 and 2 would be dismissed. Count 3, I believe, is a 93-day domestic violence charge.
Your Honor, the count 3 is a DV second.
I'm sorry. It's a DV second for 1 year. I have gone over his rights with Mr. Driscoll. He's not on
advice rights.
I do have a signed advice rights. There is a sentencing agreement to no more upfront jail time.
It's my case. I'm not necessarily agreeing to that. But
We understand that there's no cops agreement. I have gone over his rights with him. He doesn't have any questions. There's no PDA issues. He's not on probation or parole.
And he's pleading now,
No contest. We have submitted the police report.
and I have read it.
Okay, and the reason being a potential civil liability.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, Your Honor. State your name. Jeremiah David Driscoll.
All right, you can put your hand down. Sir, it is this court's understanding that you are going to plead no contest to the charge of domestic violence second offense.
Yes, Your Honor.
That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it I have to make sure that you understand. First thing you need to understand is that, first of all, means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Still wish to plead no contest?
Yes, Your Honor.
And to that charge, how do you plead?
No contest, Your Honor.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
Oh, Your Honor.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Okay. Thank you, Your Honor.
I'm sorry, I didn't hear your response.
Oh, yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 2558. Any objections to the court having reviewed that report?
Not from the people, Your Honor.
No, none from defense, Judge.
And you stipulate to the prior?
Yes, Judge.
All right, very good. Based upon a review of the report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Yes, Your Honor.
Defense is satisfied, Judge.
Court will accept the defendant's plea of no contest. 2 count 3 counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be March 3rd, 2025, 1 p.m. before me.
Thank you.